You have already read Indian Contract Act, the first part of it, up to quasi contracts, isn't it? Now, today what we are going to see is the rest of the Contract Act, the Sales of Goods Act, and the Partnership Act, right? The rest of the Contract Act is called specialized contracts. Specialized contract means that there are special categories of contracts defined in this section of the Indian Contract Act 1872. So, the first such specialized contract is contract of indemnity. Contract of indemnity. Now, let us understand what is contract of indemnity. Any meaning of indemnity according to you? What is the meaning of indemnity?
Safeguard the loss.
Safeguard the loss. Section 124 of the Indian Contract Act says that contract of indemnity, where one person promises to save the other from the loss caused by any act done by him or any other person. Loss caused by any act of him or any other person, to safeguard somebody, and that person who promises to safeguard is known as indemnifier. That person is known as indemnifier, and to whom he has given promise to protect is known as indemnified. Indemnifier and indemnified. Now, Adamson versus Jarvis. This is a very important landmark case on contract of indemnity. Adamson versus Jarvis.
So, Jarvis.
Jarvis. Adamson versus Jarvis. Now what happened? That one person was engaged to auction the goods of the defendant. So the auctioneer auctioned the goods of the defendant, but later he came to know that those goods did not belong to defendant. So he auctioned the goods at behest of defendant, whereas the defendant was not the owner of those goods. So the owner sued the auctioneer. How could you auction my property? This auctioneer had to compensate the owner, but in turn sued the defendant. And he said that please safeguard me and compensate me from this claim. Now this is called indemnity. That the auctioneer must be indemnified by the defendant, that if somebody else claims, then you shall be protecting me. Now there is a difference, that whether the contract of indemnity can be invoked only after a claim has been lodged, or can it be done even prior to that? Now, why only lodged? I mean decided. So shall the invocation of contract of indemnity has to wait till the suit is decided against the auctioneer or person like him who's suffering loss, or can it be invoked earlier? There are judgments on this point, that the indemnified need not to wait till the claim is matured or order of claim is already passed against him. The moment some suit is filed against him, he can invoke his indemnity clause against the indemnifier, that please handle this claim, it is your responsibility. So now I am indemnified. This suit is being filed against me, this is your responsibility to safeguard my interest, to protect me. Now remember, these contracts of indemnity are a routine feature in India. When you enter into a contract, normally, as a good draftsman of a contract or an agreement, you must put an indemnity clause. Now, for example, what is the most prevalent requirement of indemnity contracts in Bombay is that in Bombay, most of the people live in cooperative housing societies. Now, there are two things. One is transfer and the other is transmission. Transfer is when somebody sells his flat, shares to another person for consideration. And transmission is succession. When the original owner dies, his successors or her successors get the property and the shares and the interest in the society. That is called transmission. Now when you apply for transmission, the society demands an indemnity bond, that please declare that you shall indemnify the society from any further claims by any third person claiming to be the actual successor. So despite there being a nomination, and if the nominee is applying for transmission, the societies normally do not take chance. They insist for indemnity bond, because they don't want to take risk that tomorrow new successor crops up and says that I am the actual successor. This person may be a nominee, but I am a will holder. Do you understand the difference between nomination and will? Yes. And which will prevail? Will prevail. And there is a procedure to execute will, and that is called probate. So if a will is probated, the nomination has no value. But at the first instance, prima facie, who moves an application, and as per the society records, there is a nominee, and nominee is moving an application. So naturally they are bound to follow the nomination, but they want to be careful. And they insist, please indemnify, so that we can transmit this flat in your name and the shares. In case a new claimant crops up, then the society should be safeguarded by you, and you shall be responsible to protect the interests of the society and bear the expenses of the proceedings. The society shall not be bearing. Is that clear? Now this is called contract of indemnity.